Shall I start with the introduction of the distinguished guest?
Yes, now you can start.
Good afternoon, everyone. It's my distinct honor to welcome our chairperson of today, Dr. Vittiyaiye Teeroovengadum, ma'am, who expertise brilliantly bridges international trade law and sustainable development. Ma'am holds a PhD in international trade law and sustainable development from a prestigious Paris Nanterre University, France, and is currently advancing her scholarship with postdoctoral pursuit in public international law. She serves a lecture in the law at in a school at Middlesex University, Mauritius, where she continues to inspire future legal minds. Her academic journey of over a decade has echoingly spanned multiple continents, from beginning a respected voice at university in Mauritius to lecturing at Paris University and sharing insights at VIT University India. Each of these roles reflect her commitment to shaping legal thought across the diverse cultures. Beyond academia, ma'am has applied her expertise in governance and higher education integrity as a legal officer at Higher Education Commission of Mauritius, an impactful role in which she helped state policies at the intersection of the law and education. Today, as our conference examines the evolving landscape of global trade, sustainable and international law, we are uniquely positioned to benefit from ma'am profound academic insight and practical legal acumen. Ma'am, I welcome you on behalf of this technical session 2D Digital Criminology. I welcome you, ma'am.
Thank you. Thank you. Shall we proceed?
Next, I would like to, yeah, ma'am, I would like to introduce our co-chair person today, Dr. MP Chandrika, ma'am. Ma'am, it's an honor and a privilege to introduce you. Ma'am is a distinguished academician, administrator, and a passionate legal education and for social justice. Dr. Chandrika ma'am holds an impressive array of qualifications like BCom, LLM, MPhil, MA, and PhD, reflecting her commitment to lifelong learning and excellence in the field of law. She currently serves as a principal of BVV's SC Nandimat Law College, Bagalkote, where she has provided exemplary leadership of over 7 years. Ma'am has a teaching experience of 14 years at the postgraduate level and 24 years of experience in undergraduate level. She has shaped the academic journey of countless students. Her academic contributions include 7 articles in international journals, 19 national journals, and 5 in the UGC care listed journals, covering diverse legal themes such as marriage laws, biodiversity, banking, corporate laws, governance, and surrogacy. Dr. Chandrika ma'am has actively participated in the scholarly community, chairing sessions at international conferences, acting as a resource person in seminars, and guiding several PG dissertations. She also serves as a member of Academic Council of Karnataka State Law University and Juvenile Justice Board, Bagalkote. Her dedication extends beyond academics. She is a fellow of a Global Right for Women and holds pivotal roles in multiple committees and organizations committed to women's rights, child protection, and gender equality. Today, we are deeply grateful to have you here with us, ma'am, a scholar, a leader, and an inspiration to many. Ma'am, I welcome you on behalf of the technical session.
Thank you. Thank you. Thank you, Vittiyaiye.
Welcome you. Jen, sir, can we proceed with the first participant? Jen, sir, are you here?
You want me to say a
Dipti,
few
ma'am,
words?
yes, ma'am. Please share your views.
Okay. So I would like to welcome all the presenters today. I know that it's a very difficult slot after lunch, usually. Okay. Very difficult, and maybe you're all sleepy. But the topics for today, I had a look at the different presentation topics, are so interesting, but I guess you won't be sleeping. Okay. So I welcome all of you. All the presenters, take your time, but don't take too much time like I did. Okay, so my introduction would be very brief. So digital criminology, it's something which is here. Okay, when we talk of new technologies, AI, this is something which is changing in, I would not say minutes, it's within seconds. Okay, you are having new technologies and new crimes. So let us discuss, and then let's have the presenters, and let they talk about the different topics. Then we'll be able to discuss more. So I welcome all of you to this session, and I'd invite my co-chair to say a few words. Thank you.
It's very nice that we'll be having a session on digital criminology. Yes, of course, like Madam said, that we will hear the participants first. And I think we'll be able to show some light if there is some gap in their presentations. So, best of luck for all the presenters. Thank you.
Thank you, ma'am. We will begin with our first presenter, that is Dr. Tanvi Shams. Are you ready? Yeah.
Yes, I'm ready. Vittiyaiye, you run my PPTs.
Yes.
Honorable respected chairs, Dr. Vitti ma'am and Dr. Chandrika ma'am. I hope I'm audible and visible to you all. Thank you so much. So a brief introduction, I'm Dr. Tanvi Shams. I work as an assistant professor of law in National Law University, Odisha. And I teach like international criminal law, which is my core area. And this is the reason so I have opted this paper as one of my working paper to present in this conference today. So my PPTs are like you are sharing the PPTs, right?
Yes, ma'am.
So my title for today is like a theme, criminal digital criminology. My paper, which I will be presenting, I have named it as Technology, Tyranny, and Accountability, and Digital Tools in International War Crimes and Justice. So basically, in this paper, I'll be focusing on the aspects of how digital tools, particularly the use of artificial intelligence, are reshaping investigations, prosecutions in crimes, and accountability and mechanisms for war crimes. Basically, I'll be referring to war crimes, which are defined under the international criminal law, under the Rome Statutes. And I'll also examine the legal framework, challenges, and the ethical considerations which are involved by the use of this technology, that is in artificial intelligence, in prosecutions and accountability mechanisms in the war crimes and all. So it is very pertinent that I defined war crime. So if we have to see what actually war crimes are, so let's start with the very basics. So what do we mean by war crimes actually? So in international criminal law, war crimes are very serious violations of the laws and customs of war. Basically, they are termed as the violations of laws and customs. So these are mainly governed by international humanitarian law, often referred to as IHL. I'll be referring as IHL in my next whenever I refer international humanitarian law. Examples are willful killing, torture, inhuman treatments, hostages, taking an unjustified destruction of property, and also all elements which attributes all these traits indicate to war crimes. So the two key legal instruments here are the Geneva Convention and the Rome Statute, which I'll be discussing in brief, if time permits. So basically, the Geneva Convention protects civilians and medical persons, while the Rome Statute classifies war crimes as grave breaches of international law. Together, they ensure individuals are held personally accountable for their actions in armed conflicts and all. So the next slide, please. So there are the serious violations. To sum up, war crimes are serious breaches of international humanitarian law where individuals, not just the states, are held accountable. And our main legal foundation is provided by the Geneva Convention and the Rome Statute. So we'll have to look the aspects of the Rome Statute and the Geneva Convention. How do they like distinguish a normal like a war crime to international crimes, and how the victims are being like given like prosecutions under different challenges? But there are certain challenges, of course, in prosecution like war crimes. So despite a strong legal framework, we have the Geneva Convention, we have the Rome Statute. It is seen that legal like frameworks prosecuting any kind of war crime is not straightforward. It's very like it's not a straightforward affair to handle. First, evidence collection is extremely difficult in conflict zones. There's chaos, there's dangers, and other traumatizes witnesses. And secondly, the jurisdictional issue is there arise because these crimes often involve multiple countries. And thirdly, political interference is a huge barrier, specifically when a government is reluctant to prosecute its own military like persons or political allies and all. So these challenges make it clear why digital tools, particularly like AI, can help in as a game changers for victim like rights and all. So the legislative and framework, if we have to see the next in the next slide. So when we talk about the legislative backbone of war crimes, prosecution, we have three pillars. The three pillars are the Geneva Convention of 1949, which they set out the protection during armed conflict. Next is the Rome Statute of 1998, the founding treaty of the International Criminal Court, which prosecutes individuals for war crime, genocide, and crime against humanity. And the third pillar, we can say the customary international law, which are like the unwritten norms that they carry legal like forces reaffirming like treaty principles, etc. So all these try to assure that they both codified law and customary precedents to guide the prosecutions in such kind of war crimes and all. I have like given example of some notable cases. Next slide, in my next slide. The first is the Nuremberg trial. If we see the phase of 1945 to 46, we set the precedent for individual accountability, where individuals were held accountable even for the heads of the states and all. Next is the ICTY, where international criminal tribunals or the former Yugoslavia prosecuting high like ranking Nazi officials and all for genocides and war crimes. So it is only the Nuremberg trial and the ICTYs which are like some of the notable like precedents which have set to the international criminal courts. So the ICC like which is very like very new, very like established in a very later stage, like post like Nuremberg trials and the ICTYs. The ICC case of like to mention that like the Thomas Lubanga Diallo case, which focus on the recruitment of child soldiers. So these cases illustrate how legal mechanisms have evolved and how they have applied principles of justice in practice. The next slide. But now the question is how the use of technology will help in combating such war crimes. So the use of technology, when we say like the use of artificial intelligence in war crime investigations, here's where technology comes in modern conflicts, like for example the recent Syria and Ukraine like wars and all. AI is being used to process like satellite images, analyze social media contents, and also examine audio, video, visual recordings. So the machine learning helps direct patterns like repeated attacks on hospitals or schools, which is very much like we have been like witnessing over few like months and years now. AI also authorizes user like generated content, helping investigators geolocate incidents with accuracy. It means that the geolocation through satellites and all is made possible where the act has been done, where it has been attacked, whether it is a hospital, whether it is a school and all. The geolocation can be done with the use of drones, with the use of like technology, with the use of satellites and all. So these capabilities significantly enhance fact finding in dangerous or inaccessible areas during war crimes. So this is very pertinent that AI can aid as a like investigation tool in war crimes. So the next slide. So the utility of AI in prosecution, how AI can be used in a very positive aspect in AI prosecutions and like trials and all. So AI, artificial intelligence, isn't just about evidence gathering, like you say, it is about transforming legal analysis too. So it can help in review massive amount of documents and social media posts quickly. Suppose an incident has been occurring in Syria, we sitting back in India, we could like see the images like the blast is the like the atrocities which is going on in Syria, the Israel-Palestine war, even the Russia and the Ukraine, even the India-Pakistan like bombardments and all. We could sit back in our like own places and we can see the images gathered through this AI drones or any kind of like technologies which has been used to capture the images and circulate like massive like amount of documents are being circulated over social media posts very quickly and very like within seconds. So the next stage is to identify perpetrators using facial recognition, which is very important. Like people can be recognized by use of facial recognition. Many movies in Netflix also, which is there, which are depicting certain like atrocities of the Nazi wars and all, and also the recent like crimes of Dilo also has been documented. It stated how a criminal is being recognized through facial features, because we have seen like there are like certain circumstances where like the perpetrator are being like, there are chances where their images can be tarnished, or they're like duplicates or triplicates also are being cloned in the modern recent like times. So the predicament of attacking patterns can also be traced by the use of this technology, like how it has been attacked, through which pattern, where are the satellites are coming, where are the drones are coming, which place they are coming, what is the speed of that drone which come and attack the like place, and all these all patterns could be recognized through use of artificial intelligence. But we must be very cautious that algorithm can have biases also, and justice cannot be reduced to machine calculations. So this is one drawback of the use of AI in prosecutions of war crime and all. There can be data redundancy, there can be algorithm biases, and there can be justice that cannot be reduced to machine learnings and all. Next slide. So I'll quickly go through the legal consequences and some recommendations which I have like given for the use of like AIs and technologies in war crimes. Firstly, the use of AI, which can lead us to critical questions. Should AI ever replace like human judgment in legal decisions? This is one very pertinent question which is to like ask. The second, the answer is clearly it's a no. AI can't assess intent or proportionality, because the two essential legal concepts in war crime. Plus, large-scale data collection raises serious privacy concerns. An international framework like the United Nations guidance and AI and human rights violations emphasizes on transparency, accountability, and human oversights and all. So, moving forward, ethical deployment and robust policy frameworks are very much essential. Without having a like in India, for the use of artificial intelligence, we are like relying on the Data Protection Act. We do not have a like robust act for protecting the use or misuse of AIs and all. So technically, it is not at all possible for countries like India or underdeveloped or developing countries, which we do not have any like AI generated exclusive act or law protecting like use of technology. It is very like difficult. Last slide, please. So the final slide where I would like to conclude that technology, specifically AI, holds immense potential to strengthen war crimes, investigations and prosecutions. Of course, as we could see, like the prosecutions which are being done in these war crimes of like Israel and Russia and all. But it is also to bring new ethical and legal challenges. It brings new challenges every day, like whether it is like ethical, whether such data can be compromised, whether there can be some legal challenges, whether the law where this use of technology is being done are backed by any like the protection acts or not. So as legal professionals, we must ensure that these tools enhance, not undermine justice, and it should be a matter of accountability and human oversight moving forward. Ethical development and robust policy should be there for use of technology in like war crimes and all. So I'm happy to take up questions. So this is my paper where I have like tried to show both effect and pros and cons of use of artificial intelligence law in AI and through AI, through drones, through satellites, through algorithm in war crimes and all. If you want, I can also like tell about the dynamic version of like how there has been misuse of AIs and all, if time is being permitted. Otherwise, I'm okay to take up questions on.
Ma'am, Chairperson will give you the insights on your topic. Vitti, ma'am.
So
Over to you.
we can, if the moderator is okay, with regards to the time, we can have some questions if ever anyone from the audience would like to ask some question. I would say it's very interesting presentation, and I'm very interested to read your paper.
Thank you so much.
Yes, so let's have some questions.
Ma'am,
Audiences, if anyone has questions, 1 or 2 minutes we can spare with.
moderator, let us take the questions in the panel discussion, because specific time has been allotted
Yes,
for
sir.
questions. So let us
Yes, sir.
let the presenters finish their papers,
Yes,
and
sir.
then a specific time is there where we can take questions if there is any.
Okay, that would be fine.
Okay.
Thank you,
Thank you.
Dr. Tanvi. And can we please move to the next presenter?
Next, Jiva S. Gowda, are you here?
Yes, ma'am. Yes, ma'am. Ma'am, you will only share the screen, right?
Yeah, I
Or,
will share the screen for you.
Okay, okay. Okay. I have taken a topic digitalization and its impact on the rate of the crime. Myself, I am Jiva S. Gowda, pursuing a final year LLB at Vittiyaiye Law College, Mysore. While digitalization and its impacts on the rate of the crime, what are the topics I will be covering in this session? Ma'am, next slide. Introduction, then understanding the digitalization and crime, types of crime influenced by the digitalization, global trends, then Indian scenario, advantages of digitalization in crime prevention, what are the challenges and risk and ethical and societal implication, what are the recommendation and conclusion. Going with, ma'am, next slide, going with a definition or defining the digitalization denotes the process through which digital technologies transform business models, societal interactions, and governance mechanisms. While this evolution has led a significant advancement in accessibility, convenience, and innovation, it is simultaneously introduced the novel where digitalization maybe have a proper good advantages, but also it have a proper accessibility also, but it may create a new criminal activities, or it may be a financial gain, or it may be any political disruption or physiological uh, then going with digitalization and crime now share a complex, often relationship. On one hand, digital technologies empower the law enforcement with the tools for prediction and prevention. On the other, they facilitate the borderless while digitalization and crime, or which we can be used nowadays digitalized after 2016, where we are given a more importance for digitalization, where digitalization has been increased and digital user have been increased. Lightly, the crime also has been increased while compared to before 2016. After 2016, there is lot many cases has been filed while the digitalization of likely of fraud and all those things. Then going with next slide, understanding the digitalization and the then, ma'am, next slide. Then what are the types of crime influenced by digitalization? There are mainly there are five types, where cyber crime, hate crimes, and extremism, then traditional crimes enhanced by a digital means, and crime against the children, and financial and economic crimes. While seeing individually, where a cybercrime refers to an illegal activities conducted through digital platforms, like broadly classified into computer, maybe a computer as a target. Example, we can take computer as a tool, then computer as an incidental. Then while going within a financial and economic crimes, we can take online banking frauds, then cryptocurrency laundering, and payment gateway frauds. Then going with the crime against the child, child pornography, then online grooming, then sexual extortion via social media, where nowadays it has been become a more while sexual extortion via social media. Then what that eight crimes and extortion, the eight speech, that means talking against a country or a nation, where recruitment for an extremism group. Then going with an traditional crimes enacted by a digital means, where we can see even non-cyber crimes like theft, drug trafficking, and the human trafficking are now coordinated using a digital platform, where we can easily track the theft or a digital trafficking through a digital platform. Next slide. The global trends and digitalization and the crime rates, where we can see the mainly three topics, where that increase in the crime reporting, then increasing crime with the digital platform like crime reporting apps and surveillance tools, and underreported crimes, particularly like domestic violence and sexual harassment, are now gainly visibility. Then what is the global cyber crime data? while going with according to Interpol 2003, the cybercrime grew by over 60% of the post 2020. This shift to remote working and increase the online dependency during the COVID-19 contributed significantly. Well, we can take while COVID was being affected to India, especially during the period of 2020, it has been increased the number of digital users in India. Then digital policy in China and EU, the China's surveillance heavy model and EU's GDPR compliant digital enforcement reflects the contrasting digital policies ideologies, but however show how the digitalization can reduce some crimes forms while enabling the others. Then we can take a take a case law. Next slide. We can take a case law. United States of America versus dark side, where in 2007 2021, where the Colonial Pipeline was a largest fuel pipeline in the United States, fell to a victim, Ramson, where attack launched when a Russian affiliated to acting a group dark side. The attack targeted the Colonial IT infrastructure, likely where we can tell that a Colonial Pipeline paid it was a contract between the United States of America and the dark side company, where the Colonial Pipeline paid approximately 75 BCT as a ransom for a region access to it system. Under the dark side, where the structure affiliates to receive roughly 85% of ransom, while developers took or take about the 15%. Ma'am, next slide. Then going with the decision or ma'am, next slide. Going with the decision or outcome of this, where the U.S. magistrate judge, a northern district of the California, authorized the seizure of 63.7 BCT million, representing the affiliates' share ransom. Then what was the final? The outcome was finally significantly distributed the dark side operation by cutting the affiliated revenue, illustrating the effectiveness of the follow the money strategies and combining the criminal groups. Ma'am, next slide. And then what is the, well, going with Indian scenario, we can take a digital India and its impacts, rise in the cyber offenses, impacts on law enforcement in legal likely where in India digital India has been increased, or digital platform or number of digital user has been increased after the COVID-19. Likely the rise of criminal offenses where, or cyber offenses where due to digitalization there are maybe advantages, there are also some of the disadvantages where the offenses has been decreased. The impact on the impact on the enforcement, the legal framework. Ma'am, next slide. Go with last conclusion. Digitalization is not where digitalization may make there may be a certain advantages also, it may affect disadvantageously where it has been increased the number of as I said before, Interpol 2020 as it has been increased more than 60% of 60% of criminal means where digital crime has been reported in India. So thank you, ma'am. Thank you for this opportunity. Thank you.
Thank you, Jiva S. Gowda. Chairperson, ma'am, Vitti ma'am, do you have any insights on this? Please share.
So what we'll do, just to take very, very interesting topic, and I would say, especially with regards to the legal framework, very challenging nowadays to find a proper legal framework, especially with AI. I've been working on a research with regards to AI. So what we'll do, let's carry on with the presentations, and then during the panel discussion, we'll have a look at your different presentation and we'll discuss further. Okay?
Yes, ma'am.
Thank you.
Next, K.S. Jayakumar, sir, are you here?
Audible?
Yes, sir. You will be presenting without PPT, right?
No, madam. Orally paper presentation.
Yeah, okay, sir. You can present orally, sir.
Yeah, Okay, madam. Thank you. So, good evening to the one and all. The respected chairperson, Dr. Vitti madam, and co-chairperson, Dr. Chandrika madam, moderator, rapporteur.
Your voice is too low. Am I correct, moderator?
What, sir?
Your voice is coming very low.
Hello, sir. Audible?
Audible, sir, but it is a little lower side, sir. Can you increase the volume?
Yeah, madam. Yeah. Okay. Hello.
Sir, continue, sir.
Yeah. Okay. Okay, madam. It's audible.
It's getting better, sir.
Yeah. Okay, madam. Okay. Madam, audible?
Yes,
Yes,
sir. Very
sir.
clear, sir.
Okay. My topic is artificial intelligence and cyber crimes in criminal law enforcement and analysis. So, my present paper, case Jay Kumar, Assistant Professor, PS Law College, Mandya, and also Research Scholar, Department of Studies in Manasa Gangotri University of Mysore, and also my Guru, Dr. C. Baswaraju, Professor of Law, Department of Studies in Law, University of Mysore, inspiration for paper presentation. So, my topic is artificial intelligence and cyber crimes in criminal law enforcement and analysis. First, to beginning of the one code in the deals within the provision of regarding to the in this concept, it takes a 20 years to build a reputation and few minutes of the cyber incident to run it. Its word is denoted by the Stephen Defoe. So next concept is there are my concept is related to the provision of the 5 important of the component. One is development of artificial intelligence. How can the development of artificial intelligence? What are the important of the step? It is regarding to the provision of artificial intelligence. And the second component is artificial intelligence and regarding to the international law. And the third concept is in the concept of artificial intelligence. And the fourth concept is combating of the cyber crime relating to the provisions of the artificial intelligence. And the last important component is law enforcement in the regarding to the provision of the cyber crime aspect. So let us now move what is the important of the concept regarding to the provision of the artificial of the intelligence. The artificial of the intelligence means as per the provisions of the criteria, artificial intelligence is defined as a science that aims to understand the nature of human intelligence through a work of computer of the program. There is a simple define as per the provision of artificial intelligence. Next, let us know what is the important of the component provision relating to the artificial intelligence is a development aspect of the artificial of the intelligence. The most important of the development of artificial of the intelligence is the main important of the leading technology institution of the country. One is IITS called as Indian Institute of Technology. Second one is NITS called as National Institute of Technology. And third one is IITS III called as Indian Institute of Information Technology in India. So these are the main 3 important of the component as per the provisions of regarding to the as per the artificial of the intelligence. In case of it is a artificial intelligence researcher and startup is a regarding to the provisions of it's a main important development of the artificial of the intelligence. That is a main important component. Next, then let us now discuss the provision of the second important of the aspect regarding to the artificial of the intelligence called as international aspect. Whether any criteria regarding to the provision of international aspect, yes, it's a completely international aspect is also provision for the regarding to the artificial of the intelligence. For example, in the case of the provision of artificial intelligence regarding to the cyber crimes, some of the a number of countries. For example, only for the United States of America called as US Department of the Homeland Security called as DHS. It is used by the artificial intelligence called as National Cyber Security Protection of the System. That is one aspect. And Next, let us now in the another important of the aspect regarding to the what is the concept of artificial intelligence. It is a very important criteria. What is the important concept of artificial intelligence? There are the artificial intelligence is a McCarthy. It is a father of artificial of the intelligence. There is a number of component of artificial intelligence. For example, user interface, information based, scheller interface of the engine. That is the only for component of AI. But in the case of the branches of artificial intelligence, different branches. For example, ontology, for example, etymology, for example, heuristics, search and optimization, logic. So these are the number of branches of regarding to the provision of artificial of the intelligence. Next, let us now the fourth important of the component regarding to the artificial intelligence as per the provision of cyber crime called as a one of the artificial intelligence of component of the cyber crime called as a phishing detection. Second one is a threat intelligence. And the third one is security information and event of the management. So these are the main number of crimes regarding to the provision of combat of artificial intelligence regarding to the cyber crimes of the criteria. And some important of the cyber criminals in the regarding to the some legal framework. For example, Information and Technology Act of 2000. For example, section 66D. IT, it is also in the sum of the punishment regarding to 3 years imprisonment up to 1 lakh rupee. And the second important legal measure called as a Copyright Act 1957, Amendment Rules of 2021, and Digital Personal Data Protection Act of 2023. It's a very important aspect of one of the legal measures to the combat of the cyber crime. And last important of the component is my focus on my paper, India New Criminal Laws and cyber crime regarding to the enforcement of the provision. There are the number of enforcement of the law in the cyber crime. For example, enhanced cyber security regulation. That's a one aspect. Second aspect, regulation of artificial intelligence in the law enforcement. And the third aspect, stranger data protection of the measures. So these are the main important of the enhancement or the enforcement of the artificial of the intelligence. And also some of the important of the big challenges are several challenges combating of the cyber crimes regarding to the artificial of the intelligence. For example, big challenges is a technical complexity, lack of awareness. So for example, rapidly evolving of the threat. There is so many of the challenges, not only one or two, it is so many of the challenges regarding to the combating of the cyber crimes regarding to the artificial intelligence. Next, let us now last one provision means conclusion and a recommendation. What is the main important recommendation regarding to the provision of artificial intelligence regarding to the cyber crime? So the main recommendation is my focus on the one is develop comprehensive of the guidelines. What is the main development of the comprehensive of the guidelines? It's artificial intelligence is a law enforcement addressing issue data privacy, bias mitigation, and accountability. That's a one recommendation. And the second one is investment in the training. And the third one is foster public trust. And another one is continuous monitoring of the evaluation. So these are the main my purpose and main recommendation to the provision of it is artificial intelligence. It's last to my conclude that as per regarding to the provision of the my topic, artificial intelligence as thus per the show nothing but positive. That is introducing artificial intelligence in the field of cyber security, but improve cyber security, the huge extent and threat by the malicious actor, misuse of technology can be contained. So these are the main important of the artificial intelligence. This a present scenario. This is a most important of the important aspect of the regarding to the provision of the cyber crimes of the society. So these are the main important aspects regarding to the artificial intelligence regarding to the cyber enforcement of the law. That is criteria. Okay, madam.
Okay, sir.
Yeah.
I think you have concluded.
Thank you for giving opportunity for the paper presentation. All of the panelists. Thank you.
Most welcome, sir. Most welcome.
Okay.
The next presenter, Nalini ma'am and Aruna ma'am. Are you here?
Yes, I'm here.
Ma'am, shall I present your PPT?
Yes, sure. Please
Okay.
continue. Warm greetings to one and all present here. The topic that I have chosen, me and my author, I'm the co-author. My name is Aruna, and the author is Assistant Professor Nalina ma'am, and the presentation is going to be done by me itself because she is having some emergency, so I would continue with it. The purpose for choosing our theme, that is from courts to court, navigating digital crime to criminal justice system through legal framework. The major purpose for choosing this theme is that there is none of the crime that is left behind in digital crime. In digital crime there is everything, be it theft, be it rape, be it even threats, or the moment you think of any crime, that is already there in digital crime, and that is already happening in each and every part of the world. Be it even rape, there are so many cases for digital rape and so many cases for digital murder as well, wherein the contracts are given to kill a person, and that too, that is recorded and posted online. So there is no sphere which is left behind when it comes to digital crime. Everything is there. So there is a dire need of legislations which are binding these crimes. So this is why we chose this theme. Proceeding with introduction to the evolution of digital crime. So first we need to know how it is actually evolved. It was already there in the historical context. So firstly, as I can date back how, upon our research, it is from 1834, the French telegraph attack. So from there it is evolving till now, and it is sustaining and also growing in various dimensions. The background of digital crimes in India is shown from 2000 to 2017. That was the evolution period, as well as how it is grown to this phase where almost all the crimes have been emerging. Moving towards the technology in criminal justice systems, I am you might seem that it is just jumping from topics, but I just wanted to take up the most important topics first. So technology in criminal justice systems is really needed in India, because for facial recognition or many things require AI. And also, when AI can be used for crimes, why not use it for even solving the cases? The best example is the Kerala case, where a 19-year-old case was solved just through facial recognition through AI. So that is an example that AI has said that it can also be useful. It just depends on how it is handled. So technology in criminal justice systems is the need of the hour, where communication technologies in trials can be used. India's tech initiatives has also invested more than 53 crores for AI and blockchain integration in high courts. Then digital evidence challenges, that all of these are the most required topics in India and to be worked on. Moving towards algorithmic discrimination and predictive policing. So this matter completely focuses on how predicting policing mechanisms are working in India, and how they can be navigated into a different phase, where it can also include digital crimes and also digital justice systems as well. So in India there are so many pending cases, so there should be for petty cases there should be courts which are digital courts, which are handled by human for sure, but there should be assistance of AI that can be brought into. And then legal and ethical concerns, that also should be seen into it, that it should not be that AI is just being logical, but also ethical concerns also should be seen. Recommendations for improvement are that experts recommendation, independent ethics boards, mandated transparency, and legislative clarity on algorithmic rights should be seen. And on that, ongoing law enforcement training is also urged to address these systematic issues. Moving towards deepfake technology and evidentiary challenges, you might be seeing so many videos online which are fake, which are AI generated, and you don't even know until you notice it for 2 to 3 times. Or else when you check the comment section, that some or the other person is telling that it is AI generated. Mostly you're not able to identify if it is AI generated or not. It is so human. Only the small mistakes done by AI proves it that it is from AI. But what if the evolution is in such a phase that we are not able to differentiate? And for example, I would state that in India, 73% of the snakes are not venomous, but in through AI there are so many videos snakes posted that they are venomous, and that is increasing the rate of snakes being killed by locals. So just a similar way, just an example of snake, but it can also be through humans. Be it terrorism also, it can be promoted through AI, because the videos are generated to increase the hatred among the people. So deep fake technology and evidentiary challenges, so it can create fake videos to such an extent that evidence can that it is challenging to evidence to find the evidence whether it is true or it is just AI generated. So judicial training and expert partnerships are involved here as well. So there should be training and expert partnerships, and then involve AI into the justice systems. So that would be a complete package of Indian justice system to tackle digital crimes. Moving towards the emerging crimes in the metaverse and jurisdiction issues. The emerging crimes in metaverse is already spoken by many of them, so I would not go deep into it, but just to say that these legal gaps in virtual environments should be filled up. It should not be like there are spaces for cybercrime, but what about the AI? The personification of AI should be done, that AI is also a person and it can also be sued in a way that who is using AI to commit such crimes. So the legal gaps should be filled up. And the enforcement challenges, yes, there are a lot of enforcement challenges, but we cannot overlook them. But yes, challenges can be overcome but not overlooked. So that's what our present focus should be. And current forensic efforts, yes, forensic efforts are highly appreciated to know whether it is deep fake or whether there is an evidence that yes, it is true. The recommendations for improvement of this aspect is that legal recognition of digital personhood and mandated platform conduct codes are essential for AI and any form of digital crimes. And cross disciplinary training and international cooperation are recommended to address these issues. Moving towards crypto crimes and challenges in prosecution, exploitation of blockchain pseudo anatomy, and judicial challenges in asset seizure. So seizing assets is difficult due to private key control and lack of third party cooperation. Everyone knows about cryptocurrency today, and when our normal currency is also not safe and there are so many digital crimes, how do we speak about cryptocurrency, which is already existing only in digital platforms? So protecting that also is a very crucial aspect. So the vague law should be changed into in-depth and codified laws. So that is the purpose that we are searching for. That's why it is called as from courts to code. So there should be code, that only then it can come to the courts. There should be codes and laws relating to it. Moving towards cyber espionage against judiciary and legal systems. The rising cyber espionage threats, everyone knows about it. Judicial institutions are increasingly targeted by cyber espionage campaigns. These include sophisticated psyching attacks aimed at judges and court personnel to steal sensitive legal data. Legal data here itself is not cannot be protected, especially when you notice, just keep your phone on the side and you just say someone that you want to buy a hair dryer. For whole of a month you will only and only find ads showing hair dryers. You can just try it. I myself has tried it, and that shows that even if you, whatever you're speaking, not on the phone, you're speaking to someone else, uh, but still your phone can track the data. So legal data itself is not protected along with the general data. So that has to be looked, and that is the need of the hour. With along with that, that is the protection of data would be the stepping stone for building a digital justice system. Recommendations for strengthening cybersecurity is urgent steps include developing judiciary specific cybersecurity frameworks and mandatory multi-factor authentication, continuous training, independent oversight, and international cooperation are also essential. With that, I would also say that the dire need of cyber security should also be included in educational systems. When the general public, even in your family, you would see that when the child is studying something, they come back and tell the same to the parents or the siblings. So when it is taught in the educational institutions, that would come back to home, that yes, digital crimes are there, and these are the ways you can protect yourself and protect your data as well. Moving towards digital evidence life cycle and legal admissibility. This chart itself is self-explanatory, and I would say that the authorization and collection and private preservation are the major three aspects, that the any sources, they should be authorized, and the collection also should be authorized. With that, there should be preservation of data. With that only we can say that yes, digital evidence can be sustainable, and it can be true, which is anyone can claim upon it. Anyone can rely upon it. Cloning and documentation, everyone knows that it's not like the cloning of assignments, it's like cloning of the data that you have already have, and the legal data that can be leaked. And in the sphere where there is the a stance of cyber wars, not the normal biological war, or be it the wars that in borders, no, there is a stance for cyber war itself. So the protection of data and criminalizing the digital crime and AI or data, any form of data, that should be there. The codes should be made for it. Moving towards child sexual abuse and material in encrypted platforms. Everyone knows that in India, be anywhere you go, especially in the north, where in the town areas, you see that any child is having phones for sure. And in the phone or in the cyber, wherever they go, we can detect that they are into porn or any kind of data that should not be exposed to children. So the child sexual abuse is also arising from that, and the balancing security and rights is the need of the hour. Effective child sexual abuse material
Ma'am,
disruption requires balancing child protection efforts with.
can you please conclude in 1 minute, ma'am? Running out of time.
Yes, sure. I would in
Mm.
conclusion, I would state that technological evolution and digital crime, that evolved into its it has evolved into its best phase. And when through its evolution, there should also be the evolution of digital crimes. It should be the digital criminology also should evolve, and there should be laws made accordingly. And there is a dire need for coding and laws to be made in such a way that these crimes are punishable and sentenced accordingly. Thank you.
Thank you, ma'am. Sorry, there is a time allotment for that. I'm really sorry for.
It's all right. I can understand.
Next presenter, Prasanna sir, are you here?
Yes, am I audible?
Prasanna, okay. Yeah, you're audible. You're clear.
Can you please present my PPT?
Yes.
So very good afternoon to the panels and the audience. My name is Prasanna Nandanwar and I am from Symbiosis University. I'll be presenting my paper with the theme of exploring legislation, constitutionality, cybercrime and sciences, a cinematic analysis and interpretation of juvenile justice in digital age. So the key component of this entire research paper is Juvenile Justice Act and cybercrime. Whereas we will be more focused towards the punishment and deterrence and rehabilitation principles of juveniles within the age of 16 to 18. So I'd like to start my presentation with one sentence and one quote. It is, when society turns a blind eye to the roots of juvenile delinquency, it unknowingly shapes its own predators. Why do I say that? Ma'am, next slide, please. This entire research paper is in effect to that there is a juvenile involvement in cyber crimes because they are not punished as adults. They have more they have been given more of an they have been given more of a loose connection to the sentencing or to the punishing component. When we understand that Juvenile Justice Act and digital legislation should be conjointly read, but we see that they cannot be so equally adapted or be interpreted by the by the courts. Next, we will also look into the section 15 and its constitutionality because this section empowers the Juvenile Justice Board, which looks into the juveniles or children in conflict with laws, and they put them into preliminary assessment to be tried as adults. Further, we have to understand that this paper will also look into the validity with respect to international convention involving children. The United Nations Convention on the Rights of the Child will also be taken into account. Now, the history of juvenile justice system. So, the Juvenile Justice Act of 2015 defines child to be a person who has not completed 18 years of age, and it is an exhaustive definition where which tells us that there cannot be multiple interpretations or any liberal interpretation in the definition. Further, the objective of this act was to safeguard the children and address their unique nurturing needs. The children who had suffered abandonment, torture, neglect, or directly or indirectly needed protection from the state because of the abuse were called children in need of care and protection, whereas children who were accused of the crimes as specified now under BNS were called children in conflict with law. Further, we have to understand that the Juvenile Justice Care and Protection of Children Act became an act because India was a ratified signatory to United Nations Conventions on the Rights of the Child. Now, coming to the Indian legislation, this act became the sole skeleton umbrella to deal with the needs of the children. We have to also understand that this follows a basic principle of parents patria, where it says that the nation, the state, is the guardian of its subjects, the children, as well as the abandoned and orphan children. It was derived from the American jurisprudence of juvenile justice system. Further, we have to understand that this act gives rights and duties to both the Juvenile Justice Board and also to the children in conflict with law and children in need of care and protection. However, in 2012, a very shocking case, also known as the Nirbhaya gang rape case, judicially known as Mukesh and State of NCT, Delhi, wherein we saw a minor who was a 16-year-old or a 17-year-old was also capable of committing a heinous crime such as rape, assault, and then murder. There was a huge public outcry and the public sentiments were high at that time, which resulted in the parliament making a law and amendment in section 15 of the JJ Act, which allowed the adolescents or juveniles between the age of 16 to 18 who had been accused of heinous crimes, which is only defined in Juvenile Justice Act to be crimes which are punishable for 7 years of imprisonment or more, life imprisonment and death, to be mandatorily be having preliminary assessment to determine their maturity and realization of consequences for the offenses they have caused. This is the uh, how the evolution of Juvenile Justice Act came to be in India. Further, now the author will try to join it with the cybercrime. Now, cybercrime legislation has been so ancient in India that one cannot trace it fully. The only act that deals with cyber crimes in India is IT Act 2002, Information and Technology Act 2002, and the last is BNS, which is Bharatiya Nyaya Sanhita, which is a penal code which um, makes the punishments and gives the punishments also. It defines the offenses. Now, cyber crimes has a broad nature of applicability as it can potentially threaten an individual, a company, private entities, financial institutions, and also a state security can be hampered by this. All the while surpassing national borders. So, any one of the person, any individual, or any artificial entity can also affect somebody else's security. Now, cybercrime involves unlawful acts such as commission of fraud, identity theft, privacy violation, financial frauds, or intellectual property trafficking. Now, this we have to understand that cyber crimes can only be committed by individuals who perceive and have understanding of the technology and can actually operate on the system. It requires resources such as computer, a internet connection, and a high-speed network data. However, cyber crimes cannot be traced easily because they do not leave physical evidences as other crimes do. Next slide, please. These are the certain cybercrime examples that can be seen in today's world, like interfering or hacking into owners' access or defrauding or conspiring. Further, we have to see that my paper now, because we have known the legislature background, the author wants to focus that this paper is taking this peculiar characteristic of cybercrime and placing the liability and placating rehabilitation in the spirit of JJ Act, which is Juvenile Justice Act, which deals with children up to the age of 18. Now we have to understand that the IT Act only has punishments for up to 7 years or up to 3 years, or mostly life imprisonment in very rare cases, for example, cyber terrorism. Now, we have to understand that publishing or transmitting obscene materials in electronic form or to intercept, monitor, or decrypt information fraudulently has the maximum punishment of 7 years and no life imprisonment for them. This creates, lastly, in BNS, we have to understand it also creates a legislation or a provision which says cheating by personification or personation using technology, which is dealt under section 316 to 318, and cyber stalking as defined in section 78. Now, we have to also take into consideration that implications of an incomplete, incomprehensive legislation that can define each and every type of cyber crime is therefore necessary for India. And because we put a liability or we put a burden on the accused, it is very much imperative that we have a complete comprehensive legislation, which in IT Act is, of course, lacking behind. Now, cybercrime also has jurisdictional issues as well as establishing of lex causa, which is a uh, law of cause of action, where we cannot actually identify where the cause of action has arose and where is the locus lex loci, where is the place. Further, we have to understand that there is a JJ board, which is Juvenile Justice Board, which undertakes all the juvenile related cases. This the board is consisting of judicial magistrate first class and certain social workers approved by the state government. Now, the judicial magistrate first class does not have the comprehensible and educational and social qualifications to deal with such intricacies of crimes, where we have to, on one hand, protect the children, give them rehabilitation and not deterrence or prevention, but in the end, have the best interest of student or the children on the other hand. But we have to see in the IT Act, it is completely punishable. It punishes the person who is committing the offense. It is not protective in nature. It is not rehabilitative as well. Now, the presiding officer or the person who is sitting on the JJ board, Juvenile Justice Board, and also not the social workers, they are not typically equipped with the specialized technical and forensic understanding necessary to fully grasp the nature of modern cyber crimes. This we have to also assume that they will not have while deciding the cases or deciding the preliminary assessment of the juveniles, when they have when they are alleged to have caused substantial economic loss such as millions of dollars, or committing fraud, or having crimes, digital crimes against women. Now, the analytical question of commission of cyber and economic offenses without understanding the consequences by the juvenile brings us to a constitutionally disputed law policy, which shows which shows that now this becomes a threat, because we are punishing in one law and because we are protecting in another law. They both become a threat to the principles of justice, equity, and good conscience. The board should be perceived to have inability to respond to the juvenile delinquency or the accusations, as it is ill-equipped to determine and educate this new breed of delinquency. Now, the last and the most important point for the Juvenile Justice Act was the Section 15 constitutionality. Now, the objective of the Act was to acknowledge the unique developmental needs and enhancing the safeguards for the vulnerable segment of the population, that were the juveniles, mostly till the age of 18. On the other hand, the legislation also provide the transfer, now because of the amendment of 2012 and 15, uh, the Act was now providing provisions for transfer and prosecution for heinous crimes committed by children aged 16 to 18. Now we have to understand that it is a mandatory requirement that these children go through preliminary assessments, which are conducted by psychologists, physiotherapists, and other any social workers or any other socially equipped person who can understand and equip the person's mental ability. They also appoint professionals to go through this formal procedure. This is mostly for giving them an aid for reformation and rehabilitation in further long run because they are still young. Ma'am, we are not yet here. Yet. Can you go back to previous slide? Thank you. Now we have to also understand that the UNCRC, which is aimed, the International Convention, which is aimed to protecting the children, does not allow this Section 15 to be constitutionally valid because it is entirely aimed at protecting the children, giving rehabilitation and reformation. And India became a ratified signatory by putting this act into force in 2002 and 12 and now again 15. But just because of this provision, now India is going against international conventions. Further, we have to see the mental age and psychology. The author has brought mostly neuropsychology and other sciences to understand the preliminary assessments backing or the results that they have. So the author has mentioned a latest paper of Pickles Edwards from 2023, which is based on methodology and neurodevelopment and medical science evidence-based study, which clearly in conclusion shows that it is impossible to scientifically and also through preliminary assessment give a conclusive data report stating the person is mature enough and understanding of consequences or not. Further, this research was based on the Johnson research paper, which was published in 2009. So you can see that the author has been well equipped with the generation. It has put 2009 and 2023 showing that there is still no neurological development and sciences that can provide, that can constitutionally conclusively provide that the children have the maturity and consequence of understanding their actions. Objective evaluations based, so in conclusion, objective evaluations based solely on preliminary or age based assessment are scientifically unreliable as they fail to capture individual variability, situation influences, and developmental complexity. Lastly, the one problem that the author would like to bring is the bail offenses because the JJ Act allows bail to the juveniles irrespective of bailable or non-bailable offenses, which creates again a problem and in confliction with the IT Act as well as the penal codes. Lastly, in international conventions, we have to see that the CRC, UNCRC has five major postulates within its entire legislation. It is to ensure fair legal processes and consider psychological and social maturity before applying criminal liability and emphasizing reformation over retribution and others like addressing literacy and lack of awareness and providing access. The author has also used Beijing rules, which mostly states that there should be a specially empowered juvenile justice system to make and to create treatments and provide resolutions to the problems. Lastly, the Riyadh guidelines was also used, which also majorly focused on preventive measures. Again, not punitive, but preventive measures to protect these children in conflict with law. Lastly, the case study, mostly the entire of the paper is based on case studies. For example, last of 2025 June, there was a case reported in Kochi city where cyber police apprehended two men of Varanasi who partook in a nationwide online fraud, which was an operation by a fake government website and fake government applications. This What these people did was they used the applications and gave it to people that their vehicles have been given a notice, they should be paying fines, that there is a wrong, they have been wrongly apprehended, their vehicle will be taken, so they should be paying fines. People did. Now, when the police apprehended them and did the investigation, they found that the information, the correct information of the vehicle, the address, the person who was the victim, how was it gone? How was it derived? It was derived from a 16-year-old boy who operated Telegram and other government services to just take simple information and defraud the other people. This resulted in total of 90,000 rupees of fraud when it was brought into the attention. However, the problem here is the police were not able to arrest that 16-year-old child because no arrest or preventive detention could be made against the child because the JJ Act provides for the protection of them and only welfare officers are able to not even arrest them, take them into custody. Arrest is completely prohibited. Now we are conjointly questioning whether the Honorable Welfare Adjudication Institution is equipped and capable to carry and sort this tangled bundle of threats and precautionary steps are taken or not. We have to also take into consideration the US case where a person uh, Mr. Allen, what he did, he's again a 16-year-old boy, and in 2023, he made multiple fraud calls to the SWAT team, to the American police officers, dialing 911 operators, and telling them false information, which led to multiple problems, such as SWAT teams and officers going inside the house for precaution, but finding there was nothing. The child enjoying this so much, also digitally posted about this activities and said he can make fake calls if you pay him $35, $90, and otherwise, as is stated in the PPT for your reference. And this almost took 2 years for the police to trace. They were unable to find who was the victim, who was the accused, where was it happening, where is the cause of action, and who is the one to be held reliable. Yes, ma'am, 1 minute. Who is to be held reliable for the loss and the invasion of privacy that was happening, as well as the unrest that was happening. Lastly, there is a movie called Hack 2020 that was taken into consideration, where a 17-year-old boy is accused of rape, uh, harassing the person, digitally hacking into the systems, and ultimately giving mental harassment and digital warism. Again, in the end of the movie, you can see that that person was not punished, and the victim suffered a lifelong effects of it. Lastly, concluding, we have to understand that the ma'am, we are done with this slide. This also. This also. The solutions. Now, the analysis that the author has drawn is from the problems that the entire Indian legislation has with the Juvenile Justice Act and the IT Act is because there is an inconsistency with the principles of best interest of child, and there is a discretionary arbitrary nature of preliminary assessment that is conducted by the JJ board. Further, there is a failure to recognize the distinct psychology of digital offenders, juveniles engaged in cyber crimes often operate in as they're often operating in virtual spaces, which is completely divorced and different from physical ones. Lastly, there is a lack of institutional readiness for adolescent cyber offenders, Indian law enforcement. There's judicial institutions and the rehabilitation facilities are completely zilch in able to handle the situation, and the objective, and lastly, the objective of the JJ Act is lost here, and there is unconstitutionality with the definition of child from to begin with. So the JJ Act, JJ board is punishing the juveniles from 16 to 18 years by trying them as adults with this unconstitutional clause. So the solutions that the author has provided, first and foremost, is taking legislative action by changing the definition of child and allowing them to have better understanding of what the definition is, because the definition is exhaustive, as the author has foremost very startingly explained. It was just 16 to 18, sorry, till children from 18 years of age. They are just children and should only be protected and not arrested or tried as adults. So there should be change in the legislation. The child definition should be changed. The heinous offenses should be changed, the definition for it. The IT Act should inculcate cyber crimes in a better way, defining every type of cyber crime with every kind of punishment on the basis of circumstances. Economic digital offenses needs to be legislated. What kind of offenses are there? How much cause has been there and all this? In last, lastly, it is to conclude that there should be doctrines of parents' patry in its true form by the legislation. Thank you.
Thank you, Prasanna. Next participant, Sumaya ma'am, are you here?
Yes.
Ma'am, if there is a detailed introductions, please skip around and just go to the main topic, and we will be having around 7 to 8 minutes, ma'am. Last 2 minutes, keep it for the conclusion.
Yes.
Thank you.
Yes, good afternoon, everyone. And I am going to present the topic. Can you share my PPT? Yes, my topic is cybercrime jurisdiction, a challenge to criminal justice administration. And all of you know what is meant by cybercrime jurisdiction. Due to lack of time, I am not going to define the term, but the jurisdiction is the power of the court to adjudicate a dispute. Ma'am, go to the next slide. Yes, in this work, we have to discuss First, jurisdictional legal issues and challenges in Indian judiciary. Second one, the applicable principles of conferring jurisdiction on cybercrime, the procedural inadequacies and limitations, and the contemporary criminal procedure of cybercrimes involving multinational jurisdiction and the procedural legal implication. These are the areas we have to cover. And first, we have to look into that whenever a cybercrime investigation or a procedure is followed, we need a treaty with regard to that country. So India has already have mutual legal assistance treaties with more than 42 countries, and it had memorandum of understanding with the 13 countries with regard to criminal matters. And also India is also a signatory to several international conventions. So all this allowed India to enter into the, all these factors which helps India to make multinational extraditions and criminal procedures and exchange of all criminals and all those things are to be done only with the help of treaties. If the country is without having any treaty, it is not possible to conduct all extraditions and all those matters. So what are the principles which are to be applied in case of cybercrime jurisdictions in Indian judiciary? The first principle is applied is personal jurisdiction principle. It is based on Brussels Convention, and the Article 2 of this Brussels Convention states that person who is domiciled in the contracting state shall, whatever the nationality, be sued in the court of that state. Another applicable principle is the jurisdiction based on forum of choice. That is, the parties has the freedom to choose the jurisdiction. Next is jurisdictional principles based on civil procedure code. As we all know, it is from section 15 to 20 of Civil Procedure Code of India, mainly deals with the jurisdictional aspect. And last principle which is applied in this choice of law, that is either it is lex fori or law of the forum, or it is the lex loci. And the jurisdictional challenges that is faced in Indian judiciary, which is highlighted through several cases. That is, first one is this it is incorporated, that is many of the companies and the sites are incorporated under US laws. And second one is servers located outside India. And third one is Indian subsidiary has no operational role. And the fourth one is transaction processed outside India. Fifth one is user agreeing to jurisdictional costs in terms of user agreement and privacy policies. As that through their policy, the privacy policies, the subscribers are accepted the jurisdiction of the country which is chosen by the websites. Okay, and next we have to move to what are the procedures which is followed in the matter of cyber crime investigation and trial. And first, in the matter of multinational jurisdiction, yes, ma'am, previous slide, 8th slide. Next. Yes. In the matter of cybercrime jurisdiction, first procedural matter is the letters rogatory. Letters rogatory is a judicial instrument that facilitates the communication of court proceeding between jurisdictional authorities in different countries. Suppose a foreigner who committed an offense against India, or an Indian who committed against a foreign country, the applicable procedure is the preparation of letters of rogatory by a court. And what all are the procedures which is followed as part of letters of rogatory? That is mentioned in chapter 8 of BNSS. That is the central authority of India, that is the Ministry of Home Affairs, is the body which is entrusted with all these procedures. And procedures of letter of rogatory with regard to outgoing request. Outgoing request means a foreigner who foreigner who commit an offense in India and go back to there, and what all are the procedures which is followed by the Indian judiciary with regard to this is mentioned in section 113 of Bharatiya Nagarik Sureksha Sanhita, and it is to be stated that this concerned court in India prepare a letter of rogatory and it is to be passed to Ministry of Home Affairs through diplomatic channels or in foreign embassy, and it is submitted before the foreign embassy, and the foreign embassy shall communicate the matter to the concerned court in the foreign country. Same principle is applicable with regard to an incoming request, and it is mentioned in section 114 of BNSS. That is, foreign country, the concerned court in the foreign country prepared a letter of rogatory and it is passed to the foreign embassy, and from there it is passed to the Indian embassy. A Ministry of Home Affairs and Ministry of Home Affairs check whether there is any treaty with that country. If it is there, then it is passed to the concerned courts in India or the investigating agency. These are the procedures which is followed with regard to cybercrime jurisdiction, and it is a lengthy and hectic procedure, so it is a real challenge before the criminal justice administration. And the important, for the convenience of study, I have to, ma'am, please go to next slide. Yes. For the convenience of study, we have to classify these procedural challenges as pre-trial procedure and trial procedure. And pre-trial procedure, as far as cybercrime investigation is concerned, the pre-trial procedural challenges are, first one is the investigation procedures. That is, in the case of multinational jurisdiction is concerned, the letter of rogatory is to be prepared and is to be passed to the foreign country for collection of evidence. All these are a lengthy and a hectic procedure which delayed the justice as far as investigation is also concerned. And next challenge is the lodging of a first information report. As far as first information report of cybercrime on certain matters is concerned, the consent from the Director General of Police, DGP, is required as per information technology intermediary guideline rules. So getting a consent from an IG is not at all easy. It delays the procedure. So lodging of FIR is also delayed, which means the matter in internet is going much faster than a light. So delay in filing FIR may cause grave injustice to the victim. Another procedural issue in pre-trial is the lack of technical infrastructure. As far as the cybercrimes are concerned, many of the data are to be seized, but there was a delay. There was the lack of technical infrastructure. It means the cyber forensic labs are inadequate. There is only 1 or 2 cyber forensic labs are there for analyzing and examining all the data which are to be seized. So it is also a great challenge before the criminal justice administration. And another challenge is the lack of terminology, legal provisions, and inexperience of the concerned police officers. These are all the main pre-trial challenges. And also one other challenge is there, that is procedural bar on cognizance. Cognizance means taking notice of a crime. So when a case, cybercrime came before the court, as far as defamation is concerned, as far as defamation is concerned, the matter is the police, the courts are empowered to take the cognizance. That means police officers are not allowed to take a cognizance, means the FIR is not possible to be registered against a defamation.
Can you please conclude your presentation?
Yes. Within 2 minutes, 1 minute, I will conclude. Okay.
Yes.
Yes. So as far as first information report, FIR is not registered in the matter of defamation cases. It is to be filed only through courts. So such a procedure issue will sometimes cause injustice to the victim, and moving to the trial procedures in criminal cybercrime jurisdictional issues is the first one is innumerable cases. As there is many of the states doesn't have exclusive cyber crime courts. So the CGM court is the court which is authorized to take such cases. So it is a technical issue, and long pending trial. Long pending trial sometimes cause the retrieval of data, which leads to inadmissibility of cyber forensic evidence. These all are the main challenges which is faced by the judiciary with regard to cybercrime investigation and trial, as the technology is upgraded in every second and new versions of application developed, but the legal challenges are not resolved not at par with the technology. In addition to the inadequacy of procedural law on cybercrime, the unsettled law of jurisdiction, cyber-related offenses is a great challenge before the criminal justice
Thank you, ma'am.
administration. Thank you.
Thank you, ma'am. Sahil sir, you are here. I can give you
Yes, ma'am.
4 minutes. Please conclude your seminar.
Yes.
Please don't go into very detailed introduction and everything. Come to the topic. Since you have missed the presentation in
Morning session.
technical session 1C, we are allowing you to present it here.
Yes, ma'am. Good evening, everyone. Today, I am here to take part in the international conference on the topic of human rights-based approaches to the criminal justice reform in India, challenges, strategies, and the way forward. The criminal justice system in any country is designed to enforce the rule of law, protect the individual rights, and maintain the public order. In a diverse and democratic nation like India, this system's legitimacy depends heavily on its ability to uphold human dignity and equality. Unfortunately, the system in India continues to operate within colonial era framework. It faces severe criticism for being overly adversarial, punitive, and discriminative, especially towards the marginalized communities such as Dalits, Adivasis, Muslim, women, and LGBTQ plus individuals. Despite the constitutional protections, India still struggles with the issues like custodial violence, prolonged pre-trial detention, judicial delays, and overcrowded prisons. A human right-based approach offers a corrective framework. It moves the focus from the punishment and control to fairness, dignity, and accountability. HRBA demands that national laws and institutions be aligned with the international human rights instruments like Universal Declaration of Human Rights, the International Covenant on UNCCPR, and the United Nations Convention Against the Torture. Though India has not ratified the latter, its principles are increasingly referenced in the court rulings. HRBA promotes legal reform, capacity building, civil society involvement, and victim-centered justice. However, implementation has been sporadic due to the political interference, lack of resources, and resistance from the enforcement agency. To apply HRBA effectively, we must examine its legal and conceptual framework. Internationally, India is bound by several key human rights instruments. The UDHR emphasizes the right to a fair trial and the presumption of innocence. The ICCPR, which India ratified in 1979, outlines the rights to life, liberty, legal counsel, and human treatment. The UNCAT, UNCAT, though not ratified by India, has significantly influenced the Indian jurisprudence. HRB must also function across the triad of the police, judiciary, and prisons. Police reform is central as law enforcement is most citizens' first point of contact. Yet, the custodial torture, arbitrary arrest, and lack of accountability remain serious problems. The judiciary tasked with the upholding constitutional rights struggles with overwhelming case backlogs. Public interest litigation and suo motu actions offer some remedies, but access access to justice remains uneven. Prisons, meanwhile, continue to operate under the outdated Prisons Act of 1894, lacking any human rights orientation. The Model Prison Manual of 2016 is a step forward, but implementation is patchy. We must now examine the significant challenges that HRBA seeks to address. First is the police access custodial violence. The NCRB reports over 150 custodial deaths in 2022 alone. Most of these do not result in the prosecution. Investigations are slow, biased, and quietly closed. The DK Basu judgment has laid down procedural safeguards, but compliance remains weak. Second is the problem of judicial delays. India's court have over 5 crore pending cases. Under trials make up 75% of prison population, often incarcerated for years without trial. Many are too poor to afford the bail or to access the legal aid. Third, the prison conditions are inhuman, overcrowding, poor hygiene, lack of medical care, and absence of rehabilitation programs violate the fundamental rights. Vulnerable
Sorry,
groups
sir.
such as, yes, ma'am.
Sorry to interrupt you. I can just ask you to, can you just wind up in 30 seconds, please?
Yes, ma'am.
We're running out of time, so sorry.
Okay, ma'am. Lastly, we must reform our philosophy of justice. Punishment must give a wave of reformation. Open prisons, post-release rehabilitation, and sports services are essentials to reintegrating former convicts and reducing the repeat offenders. In conclusion, a human rights-based criminal justice system is not just a policy choice, but a constitutional and moral imperative. Justice in India will be meaningful only when every step from arrest to adjudication and rehabilitation is anchored in dignity, fairness, and equality. Let us build a system that protects not only the innocent but also upholds the humanity of every individual, regardless of caste, class, religion, or gender. Thank you.
Thank you, sir. Vitti ma'am, we will move towards the concluding remarks.
Yes. So thank you very much. So thank you. All the presentations were very interesting. So we have been talking about different topics, how digitalization has transformed and is still transforming crimes and the justice system. So we have been talking about AI in war crimes, how it is being used to examine large amount of information, to collect evidence for pattern identification. We some have been talking about the use of AI nowadays. For example, you have the Kerala case. Very interesting. I've read about it before. So how they have used AI to solve an existing case, how the Indian government is investing in new technologies and AI for use in court. We have also talked about digital court, how we can consider the option of having a digital court, but it has also been put forward that AI is here to help. Okay, we should be careful of any possible biases, how it would not replace advocates, it would not replace legal professionals. It would be here only as a tool. It has also been put forward the need to have a proper legal framework, an accountable, a legal framework who will take into consideration accountability, especially when there is this use of AI, how this legal framework has to evolve rapidly because new technologies and AI, they are evolving rapidly. So it has also been discussed the different types of cyber crimes, particularity of cyber crimes, practical difficulties in the enforcement of such crimes, the need for international convention and their application, and several examples have been taken. I would not elaborate on the different presentation because of lack of time, but each one of them have contributed to make this session very successful. So I would invite members from the audience to ask their question rapidly because we are running out of time, and we continue with the discussion. So the floor is open for questions. None,
I
no
don't think
questions.
there are any questions. We will just move to the concluding remarks by our co-chairperson, Dr. Chandrika ma'am. Ma'am, are you here?
Yes, yes, very
Yes.
much here. Good evening, everybody. As Dr. Vitti ma'am said, yes, it was a beautiful presentation. I feel that there is a lot of research carried on by each of them. This, what we are speaking about, digital criminology, has three phases. One is crime and the criminal. The second is the victim, or what we speak about is victimology. And the third is the punishment, that is the penology. I could get from the paper presenters that all of them have focused in a specific area of the digital criminology. This is in a primitive stage. Yes, much research has to be carried on. I would recommend that whatever has been done by the researcher to this should not stop. We need much and much research so that we can have, as all of them have pointed out, some saying lack of laws, some saying lack of enforcement agencies, some also mentioned a judicial training. Yes, everything is a part of digital criminology. So continue with the research and we can have a concrete legislation in India so that we can curb all the type of cyber crime in total. Thank you, one and all. And I thank the organizers for giving me this opportunity, especially Dr. B.M. Kukkadi sir. Thank you, one and all.
Thank you, ma'am. Now I request Akansha, first year PG LLM student, Department of Law, Central University of Karnataka, to conclude with the vote of thanks. Akansha, are you here?
Yeah,
Okay.
good evening, everyone. It is my privilege and honor to deliver the vote of thanks for this enriching and intellectually stimulating session, Technical Session 2D. Digital Criminology organized international conference on criminal jurisprudence by the Department of Law, Central University of Karnataka. First and foremost, I would like to express my deepest gratitude to our chairperson, Dr. Vittiyaiye Teeroovengadum, lecturer at Middlesex University, Mauritius, and our co-chairperson, Dr. M.P. Chandrika ma'am, principal, BVS SC, Nandhimat Law College, Bagalkot. Thank you, ma'am, for your gorgeous presence, keen observations, and thoughtful feedback that added and directions to this session. My sincere thanks to our moderator Vijayalakshmi Baswaraj for seamless guiding us through the presentations and maintaining the decorum and academic flow of the session. I extended my heartfelt appreciation to all our paper presenters who brought forward a wide spectrum of ideas. Each presentation has added immense value and sparked important questions and reflections. A special word of a special a special word of thanks to our reporters L. Arun Kumar Raju, research scholar, Department of Law, Central University of Karnataka, whose hard work behind the scenes has made this session possible. Your coordination and commitment deserve high praise. Lastly, I thank all the participants and attendees for their patience, active engagement, and for being part of this academic discourse. With your presence and interest contribute significantly to the success of such session. With this, we formally conclude technical session 2D. Thank you all once again, and I wish you a fruitful continuation of the conference ahead. Thanks to all.
Thank you, Akansha. Thank you, everyone.
Thank you, Vitti ma'am, and thank you, Sandrika ma'am. We also request you that now only we are going to start the valedictory session on the same link. So we request all of the participants who are attending just to attend the valedictory session. Thank you.